This is Bloomberg Law with June Grasso from Bloomberg Radio.
The U.S. Supreme Court will take up a new clash over the use of race in redistricting, agreeing to hear arguments on a Louisiana congressional map that creates an additional majority black voting district. But the court won't hear arguments until early next year, and the 2024 elections are proceeding under the challenged map, which could boost Democrats' chances of retaking the closely divided House of Representatives. This is the latest step in more than 2 years of federal court battles over Louisiana congressional districts. The state has had 2 congressional maps blocked by lower courts, and the Supreme Court has intervened twice. Joining me is Bloomberg Supreme Court reporter Greg Stohr. We've been hearing about this Louisiana map for years, so tell us the history here.
Yeah, it's a convoluted history. The key practical question is whether there has to be a second majority black district in Louisiana. Louisiana has 6 congressional districts. About 33% of the state is black, and the question is, when the districts are being drawn, is it enough just to have one majority black district? And so there was a Supreme Court decision back in 2023 involving Alabama that was very similar, in which the court essentially said, yeah, Alabama has to have a second majority black district under the Voting Rights Act, which basically protects minority voters from having their voting power diluted by the way districts are drawn. And it seemed like Louisiana was going to go the same way. But then another group of voters, opposed to the second majority black district, sued and said the way the state drew this up is so convoluted, it's so gerrymandered that violates the U.S. Constitution. They used race too much in doing that. And so this case at the Supreme Court is going to sort of determine the balance between those two issues. The Voting Rights Act that says essentially, create a minority district when you can, and the Equal Protection Clause, which the Supreme Court has interpreted to put limits on the ability of map drawers to use race.
The disputed map will be used on Tuesday.
It will be. There will be a second majority black district on Tuesday in the election, and that will probably be a shift, another Democratic seat in Congress because of that new map.
And explain how there have been unusual dynamics in this case.
Yeah, so interestingly, both the Republican-controlled states, including the Republican Attorney General Liz Murrill, and the NAACP Legal Defense Fund asked the Supreme Court to intervene and uphold this map. And the state argued, look, we're being put in this ridiculous bind. On one hand, we had been, because of another court case, ordered to create a second majority black district. And on the other hand, this different court comes along and tells us, nope, you used race too much. And so Louisiana argued that even though we didn't agree with the original decision requiring a second majority black district, here you're basically turning us into, the way Liz Murrill put it, we're like a ball stuck in an endless game of ping pong. And she argued the state's got to have a little breathing room to create districts.
And so while I have you, Greg, just explain what the court did or didn't do as far as Pennsylvania on Friday.
Yeah, so this was a case where Republicans were asking the Supreme Court to intervene and stop some provisional ballots from being counted, potentially tens of thousands of provisional ballots. And what these are folks who voted by mail, and there was something wrong with their mail-in ballot. Like, for example, they didn't include the required secrecy envelope. And so under a Pennsylvania Supreme Court decision, those folks were going to be allowed to cast provisional ballots so that the original flawed ballot wasn't going to count, but they could go to the polls and vote anyway. And Republicans were asking the Supreme Court to intervene and say, no, those folks are not allowed to cast provisional ballots. They basically lost their chance because they submitted that flawed mail ballot. And the Supreme Court said, no, we're not going to intervene. Essentially, we're going to let those votes be counted. None of the justices dissented. There was a statement by 3 of the conservative justices on some aspects of the case, but no disagreement at the Supreme Court about letting those votes count.
But there was disagreement among the justices earlier in the week on Wednesday about Virginia purging voter rolls. That was a 6-3 decision.
Yeah, well, they're very, very different legal issues. The Virginia case was all about whether that state could purge its voter rolls in the run-up to the election, just before the election, in what it said was an effort to remove non-citizens from the polls, even though at least some folks who were citizens were also purged from the rolls there. The Pennsylvania issue was very, very different in that it's the kind of thing we might actually see after the election if the election is super close. It's a question of how quick will the U.S. Supreme Court be to jump in and say, State Supreme Court, you misinterpreted your own law, and we're going to overrule you. And at least this one particular data point says at the moment, the U.S. Supreme Court is not that interested in telling a state Supreme Court that it's done something wrong and, for example, should not have counted some votes.
Thanks so much, Greg. That's Bloomberg News Supreme Court reporter Greg Stohr. Turning now to the $1 million a day voter giveaway by Elon Musk's pro-Trump super PAC that the Philadelphia district attorney is trying to stop as an illegal lottery. Here's how Musk has characterized the giveaway.
We're going to be awarding $1 million to randomly to people who have signed the petition every day from now until the election.
But today in court, Musk's lawyer made a surprising admission, saying that the winners are not chosen by chance, but are selected based on their suitability to be a public spokesperson for Musk's Political Action Committee. Bloomberg's Chris Dolmetsch was in the courtroom. Chris, tell us about this admission.
What's clear is that Musk said on stage, these people are being chosen at random. And what the treasurer for the PAC testified today is he said he was a little bit surprised by that because essentially what they are calling it is an employment contract, that these people are chosen, once they sign the petition to refer others, they're chosen based on the number of people they refer, their social media posts, things like that. And it's not because they're just chosen at random. They made that pretty clear during the hearing. And that's why they say it's not an illegal lottery. They're basically saying they're employing these people, and the work that they're doing is making videos, speaking on behalf of the PAC, that sort of thing.
I mean, did the people who signed up for this know that that's the way they were being chosen?
Well, it's not clear. So at least the first person was chosen before he was told. He was told he was going to appear on stage. He made some videos, but he didn't know until that moment when he was selected. And as to the other winners, it's not clear how much they knew or what they suspected, but they were also told that they were going to appear on stage. So the possibility is that they were not really in the dark there as to what might be happening.
Tell us about the testimony of the Philadelphia DA, Larry Krasner.
He said essentially that he views this as a violation of both states' lottery laws and its consumer protection laws, mostly because they're taking the individual personal information of the people who got the money. He also argues that the lottery laws are being violated because they require three things: there to be a prize, there to be an element of chance, and for there to be compensation, meaning that somebody has to pay to get in. He contends that the pay that they are giving is their information and that it therefore violates the state laws. And he argues they're not protecting their personal information. He said they're essentially trying to buy votes. So it was relatively testy at points during the cross, but it was all in all a mostly congenial exchange.
What was his reaction to their saying that now this is not a lottery? It's not random.
Well, the Philadelphia DA was incredulous, to say the least. He called it one of the more disingenuous arguments he's ever heard during his decades of practicing law. He contended that it was essentially nonsense. He thought it was outrageous, to say the least. The most entertaining part of it, without a doubt, was he was asked to be able to testify. He said he asked to be able to 2016. He used to be a mechanic, and he appreciates the vehicle. And then he was asked about, the political accusations that he's doing this simply to score political points. And he said if Taylor Swift did the same thing, he would bring a complaint against her.
Was Elon Musk there? He was supposed to attend, right?
He did not. And honestly, it was kind of interesting because, the judge said last week he's supposed to be here, and he clearly was not. He didn't testify. He didn't even there was no real address to that other than the DA pointing it out once again. So whether the judge, gives that any weight as to credibility and that sort of thing, the DA, implied that, basically they're running away from it. And the fact that he didn't show up is them not addressing it.
Thanks so much, Chris. That's Bloomberg legal reporter Chris Dolmetsch. Shortly after the hearing, the judge ruled that the $1 million a day sweepstakes can continue through Election Day. He did not give his reasons for that decision. But Musk's lawyers in closing arguments had called it core political speech, given that participants sign a petition endorsing the U.S. Constitution. They also said that Krasner's legal bid to shut down the sweepstakes under Pennsylvania law was moot because there would be no more Pennsylvania winners before the program ends tomorrow. The first 3 winners came from Pennsylvania. Other winners came from the battleground states of Wisconsin, Nevada, Arizona, Georgia, North Carolina, and Michigan. Krasner has said he could still consider criminal charges as he's tasked with protecting both lotteries and the integrity of elections. Coming up next on the Bloomberg Law Show, 2 prosecutors fired by Florida Governor Ron DeSantis are asking voters to reinstate them. And I'm June Grasso, and this is Bloomberg. Florida Governor Ron DeSantis removed 2 elected prosecutors from their jobs, saying they refused to enforce the state's laws. Now Andrew Warren and Monique Worrell, both Democrats, are asking voters to reinstate them as district attorneys. Joining me is Alex Ebert, Bloomberg Law senior correspondent. So, Alex, tell us about these 2 former prosecutors who are running for re-election, despite being ousted by Ron DeSantis.
So these 2 former prosecutors, both progressives and both outspoken critics of Governor Ron DeSantis, were both terminated by the governor, he says, for refusing to follow the state law. And they say it was all part of their discretion and their ability to pick and choose what crimes they're going to tackle.
And so tell us about the court battles.
Absolutely. So the court battles range from state and federal, and they both didn't go the prosecutor's way. On the state level, both Andrew Warren, and he's in Tampa, and Monique Worrell, and she's in Orlando, they sued in the state Supreme Court seeking a special writ to get them back into office. And the state Supreme Court said that Warren, he waited too long to sue. He started in federal court. And Worrell, she didn't have enough backing to her complaint. Basically, they ruled that, Warren, you were too late, too short, and Worrell, what you did is arguably within the discretion of the governor to get rid of you for.
And now they're running for the same seats that they were ejected from by the governor?
That's right. They're running for their old jobs back. And both of them are in districts that Democrats do pretty well in. Worrell won a landslide back in 2020. She had like 60% of the vote. Warren was around the mid-50s with his election, and both of them are once again running against prosecutors they think they can take on.
And are they running against the prosecutors that DeSantis put in place after he removed Warren and Worrell?
Indeed, yes. It is like they're running against the X's, right? So in Tampa, we've got Warren running against State Attorney Lopez, who we interviewed with for our piece, and she touts all of her great relationships with local law enforcement. She was in the office for over a decade, and she was tapped to be a local judge before being tapped once again by DeSantis to take over that state attorney's office. You know, she said that she's focusing on prosecuting more low-level crimes and focusing more on the interest of victims than Warren did when he was the prosecutor there.
I mean, have there been polls out to see, who's doing better?
Not to my knowledge. I got with the attorneys that were running here, and they didn't share with me anything. What is well known is how sort of striking the voting public is here. You have districts that lean Democrat, especially in the Orlando area. And even though DeSantis was winning across the state, these individuals were able to easily win their offices 4 years ago.
The amount of money being poured by conservatives into these races is just amazing. Backers of DeSantis' replacement for Warren, Susie Lopez, have spent $2.1 million on ads, and groups supporting the other DeSantis appointee, Andrew Bain, have spent $2.3 million.
It is eye-popping. So the amount of money involved in the 9th district race, that's Worrell, and the 13th district race, that's Warren. Together, that is more than 4 times as much as you're seeing spent statewide. And in those specific races, the Republican or conservative sides are vastly outspending the Democrats. You see figures as much as 10 to 1 spent in these races, seeking to have these conservatives hold on to their posts.
If they do win, will DeSantis remove them again?
This is an open question, and it's one of the reasons why this has become such a flashpoint for this broader discussion across the country. We've seen states where progressive prosecutors were recalled, right? Or they've faced immense criticism and they lost their next election. But this is the first and second instance where we've seen a governor literally remove the progressive prosecutors just because of a difference in discretion. You had Warren, who had refused to enforce abortion-related crimes, and you had Worrell, whose policies were to seek more diversion and more non-bail-related pretrial release. And because of that, DeSantis said that he could remove them. National experts in criminal law and others that follow this issue closely say that this could be a template for other governors or even a Republican president to seek to remove or work around local prosecutors.
You know, there have been different places where these conflicts have arisen. Do they only arise when it's liberal prosecutors elected in cities in a state with a conservative governor or legislature?
Experts at the ABA discussed this topic with me. They've researched this issue really thoroughly. And what they've come across is that you're seeing mostly this occur with progressive local prosecutors and Republican governors. However, you've seen for years this issue where Democratic governors or state attorneys general will seek to take issues off the plate of the local prosecutors or seek to bring cases that local prosecutors won't bring. You've seen things like that in states like Massachusetts, Minnesota, Michigan, where, liberal executives or other state officials will sort of work around the local prosecutors and do things they don't want. The most high-profile version of this was back after the Dobbs decision came down, Michigan Attorney General Dana Nessel came in and she wrestled power from local prosecutors, saying that, no, you can't bring abortion-related crimes. She went to court to get a declaration from a state court saying, no, that's the job of the state attorney general, and our policy is that we're not going to prosecute these.
Has anything like this happened in Texas?
Indeed. It's an open question in Texas. My colleague, Ryan Altulio, the great correspondent we have in Texas, did a great story about this last week on this very issue where there's a judge that will be considering whether a district attorney there should be taken out. There's other issues in Georgia surrounding the prosecution of Trump and in Tennessee where lawmakers there are actually campaigning on possibly taking out a progressive prosecutor.
These progressive prosecutors were probably elected by voters in a city or area that is more liberal than the state. How does the governor have the right to take away their vote?
So I had pretty in-depth conversations with national experts for this story over several months. And the bottom line is that there's a gray area here. So prosecutors, under the law, they have unlimited discretion. But at the same time, there's court rulings that say if you're categorically refusing to enforce, parts of the state law, that might be reason to say that you're not actually doing your job. DeSantis is leaning on some Florida precedent in his state that says basically exactly that for a prosecutor that refused to prosecute gambling issues. So, both sides have pretty strong legal arguments. And the question is, how do we balance that need for, the protection of local citizens against crime with the ability of prosecutors to innovate and to consider what's the most important thing for them to do? Because at the end of the day, we can't prosecute all the crimes. The question is, can we look the other way if certain crimes should be prosecuted?
Do these cases arise only when a prosecutor says, I'm not going to prosecute abortion-related crimes, or I'm not going to prosecute gambling-related crimes, where a prosecutor is sort of, drawing a line in the sand? Or does it happen because they notice that prosecutors are not going after certain kinds of criminals?
That's the distinction between Warren and Worrell, right? So Warren is one of dozens of prosecutors whom, after the Dobbs decision, came out and signed a statement saying, I'm not going to prosecute abortion-related crimes. And the interesting thing for Warren's perspective is there have been no, crimes like that committed inside of his district, and both Republicans and Democrats will point to that. But regardless, that categorical bar got him in trouble. With Worrell, it's different. The Orlando attorney, she got in trouble because of her policies, which DeSantis said reduced sentences at jails, so there were fewer people being jailed, and because criminals that, normally would have been locked up prior to trial, because of her policies, were able to, be outside of the carceral system at the time and had committed crimes. And so he pointed to that as a version of incompetence, while she pointed to that as something that she was trying to implement with her discretion to improve the local criminal justice system.
Tell us about these legislators in 27 states, that the bills that they filed.
This was a topic that I hadn't expected to come up when I was looking into this. Often at Bloomberg Law, we do sidetrack sort of legal and legislative analysis to look at this. But a law professor brought this up and said that there are 27 states where legislators are seeking to improve governors' ability to remove local prosecutors. Many states, they're not going to have the ability to do that unless there's some sort of truly bad ethics issue or competence issue, or, as the experts told me, issues revolving around, drug use or alcoholism in an office, right? Those are instances where we've seen these things happen in the past. But lawmakers here, typically Republicans, they're looking to empower the governors to remove people the same way that DeSantis did. And that's something that in Project 2025, you see the Heritage Foundation encouraging the next president of the United States to consider doing as well. Their argument is, if you're not enforcing all the laws in a particular jurisdiction that are getting enforced in other parts of the state, that's not equal protection under the state constitution or federal constitution, because you could be, put in jail for a crime in one area and not in another. Whereas, the people that are criticizing these lawmakers, they say this is actually undoing the votes of local voters who want to have their policies followed and the crimes they think most important, be the emphasis of their state attorneys.
And you talked to someone who said there was a concern about prosecutors worrying about keeping their jobs instead of worrying about the job that they're doing.
Professor Ellen Yarashevsky over at Hofstra Law School, she's one of the co-chairs of this American Bar Association criminal law section that is studying prosecutorial discretion. And what she said is the main concern is that instead of sentencing how they should based on the local rules and, what they're seeing at their office, or filing charges that properly align with their priorities, prosecutors, whether they're Democrats or Republicans, now might have to look over their shoulders and think, what is the governor going to think about this, instead of what is the best thing for my local community? She said that extends from bail to sentencing to charging. Are we going to over or undercharge? Instead of using their own discretion, she's worried, and folks at the ABA are also worried, that we're going to see prosecutors now think first, what would the governor want?
Thanks so much for being on the show, Alex. That's Alex Ebert, Bloomberg Law senior correspondent. Coming up next, the justices hear arguments over the False Claims Act. This is Bloomberg. Today, the justices considered what a government dollar is in a Federal Communications Commission fraud case. Whistleblower Todd Heath filed a False Claims Act suit in 2008 alleging that telecommunications provider Wisconsin Bell overcharged schools and libraries for services under the FCC's E-rate program, resulting in the fund paying out more money. But Wisconsin Bell argues the government couldn't have been harmed by the alleged misconduct because the fund is financed by the telecommunications providers and not the federal government. Joining me is Joe Whitley, a partner at Womble Bond Dickinson. He's the former U.S. Attorney for the Middle and Northern Districts of Georgia. So tell us about the issue here.
This is the False Claims Act case being brought by a relator by the name of Todd Heath. And Mr. Heath filed this action in the name of the United States, That's how the False Claims Act statute works. But before he filed, he met with the United States on this filing, and the United States at that time decided not to intervene and join Mr. Heath in the action. So this action then was filed in the Eastern District of Wisconsin, and a district court there in the Eastern District granted summary judgment to Wisconsin Bell. And Mr. Heath, the relator in this case, appealed this case to the Seventh Circuit, and the Seventh Circuit reversed the district court. But then Wisconsin Bell appealed this case to the U.S. Supreme Court.
Wisconsin Bell is saying that the government doesn't provide money to the company that administers the Universal Service Fund. When the post office delivers a birthday card with a $20 bill inside, no one would doubt that grandma, not the government, provides the cash. Explain their argument.
Right. They're saying that the money that is being distributed, or the funds that they have in the account that they provide money to, is not federal money. In other words, I could go back to 1863 when the Congress passed the first version of the False Claims Act. It dealt exclusively with federal money, in other words, money that had been appropriated by Congress for the provisions that were needed during the Civil War. There was a lot of corruption happening in terms of government contractors providing materials to the Union government, the United States government, during the Civil War. So at that time, that was what it is contemplated to cover, only monies appropriated by Congress. And in this circumstance, Wisconsin Bell is saying, in present day, all of the money that's in the account, the distributed out or provided reimbursement to telecommunications providers, is not public money, not appropriated by the Congress, and it's not money from the U.S. Treasury.
And does the government agree with Wisconsin Bell or the other side?
No, the government is taking the position that this provision could reach these funds and that there could be actionable cases against telecommunication providers if they don't provide in other words, the issue was Wisconsin Bell providing the lowest possible rate to schools and libraries, and the relator says they were not providing lowest corresponding price, also known as LCP, under the C-rate program. So there is at least some suggestion that the government sees this, I would think, as an opportunity to reach other conduct where there could be, there's an argument the government would be making that this does reach the conduct of Wisconsin Bell.
Is that also the argument of the relator?
Yes, the relator believes that the funds are from the U.S. Treasury in the sense that some portion of the funds are fines, delinquent payments, criminal fines. Some small amount of money actually in the fund is arguably from the government. Relator is also arguing that the fund is also, or the E-rate program, is acting as an agent of the United States under this program because of the provisions are legislated and are regulated. And then Congress is also involved because, whereas they set up this program via the regulations that the FCC created, and they believe that the position of the Fifth Circuit is incorrect, and that this is covered by the legislation, and that this should be conduct that falls within the False Claims Act.
I mean, which argument do you think is better?
I have a bit of a bias, having been a federal prosecutor and having been a U.S. attorney in two different offices here in Georgia, Atlanta and Macon, and then also serving in the Department of Justice in a number of high-level positions. I would prefer that this is a direction that we should go in, that this be legislated by Congress, that Congress take a look at the reach of the False Claims Act. And if Congress deems there to be a need to expand coverage here under the False Claims Act so the E-rate program would be covered, I would suggest that would be a better path, because there is some suggestion that if this case were to be resolved in favor of the relator's arguments, that False Claims Act cases could be brought against the Fannie Mae and Freddie Mac programs, which are mortgage programs that provide insurance for mortgages. In situations like that, this could also cover perhaps the Boy Scouts that are set up under federal law, and the Veterans of Foreign Wars perhaps is another group that could be covered. And the damages in these cases are extreme. In other words, if you're a mortgage company and you're using Fannie Mae or Freddie Mac as for insurance on your mortgage, if you provide information that somehow is deemed to be false, you might be facing treble damages, which could be substantial, and then fines of $5,000 to $11,000 per claim that you might have filed with the government, arguably. So I don't think any of this was contemplated, and I guess maybe some thought about this kind of original intent, if you will, in the legislation going back to Lincoln and Congress in 1863. I just believe that this is a step beyond what is contemplated under the law, and it should be legislated by Congress, and then the FCC could provide regulatory coverage for this. But I think it's a step too far, in my opinion. I believe we shouldn't have the Supreme Court or any court legislating. And in fact, I think that's what the Circuit Court did in the Seventh Circuit.
So how do you think the Supreme Court will rule?
Well, I think looking at the most recent Chevron case and how the Chevron case came out, in other words, that Chevron had been a doctrine that most administrative lawyers kind of took as a given in their analysis of administration or administrative regulations. And I think that is a harbinger for this case. I think the Supreme Court will side with the Fifth Circuit in terms of this circuit split. I think they will say that the reach of the False Claims Act does not reach circumstances like this where the funds are not government funds, and will suggest that the role of Congress should be part of this in our separation of powers government. And if Congress deems that the reach of the False Claims Act should cover this particular fund, that should be legislated. And I think in a 6-3 decision, I can see there may be being a split in the justices, or it could be, they'll all agree and have a 9-0 decision. But I don't see this as a political case, but I do see it as what role do relators have, and what roles do plaintiffs have in sort of structuring the law here. And I think that the prevailing provision or prevailing opinion is that this action is not supportable under the False Claims Act.
Do we know how much money is involved here?
I think that would be determined in the litigation in court, but it would be, I believe, in the tens of millions of dollars that Wisconsin Bell might be arguably liable for. I can't give you an exact amount, but obviously Wisconsin Bell would not be litigating this unless they thought it merited their doing so. And I think they've done a good job. Nonetheless, we're talking about millions of dollars, not only in this case, but in many, many other cases that could be brought, assuming the court takes a more expansive view of the False Claims Act.
Thanks so much for joining me. That's Joe Whitley of Womble Bond Dickinson. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.